right, hello everybody. I've given everyone, given the latecomers 5 minutes to arrive, so we can sort of get started. Hi, thanks for coming on this Monday evening, and I'm sure you have other places you could be, so it's really nice for you to come along. For those of you who don't know me, and some of you do and some of you don't, my name's Dr. Matt Lodder. I'm a lecturer in contemporary art in the... I thought I waited long enough for the latecomers, and I didn't quite. That's all right. Hello. So, as I was saying, yeah, I'm a lecturer in the School of Art, History and Philosophy. I am a lecturer in contemporary art, but my kind of research interests particularly are in the history of tattooing, and particularly the history of tattooing as a professional artistic practice in Britain. So that's basically 1870 to the present day. And I'm currently working on a book entitled Tattoo and Art History, which is kind of an overview of those histories. This talk today basically comes out of the fact that when I started at the university in October, as a new lecturer, keen to sort of say yes to everything I was asked, they said, can you do a talk for the Human Rights Centre? And I said, yeah, I've got a few ideas bubbling away, but give me till February, right? Give me till February and I'll kind of let them percolate and come up to the surface. Of course, February wasn't as long a way as I'd hoped it would be, right? So essentially this has come around very quickly for me. But suffice to say that there are issues of human rights that come up frequently in my work, right? Issues of corporeal autonomy, so bodily autonomy, bodily integrity, of the borders between a public and a private life, of consent, of discrimination, of race and gender and sexuality. Though they cannot be said to be, by any stretch of the imagination, my kind of area of expertise. Human rights is not the particular kind of methodological focus of my research. Instead, right, what I hope this evening's talk will achieve is to illustrate in general the value of the utility of human rights discourse, illustrate the kind of general interdisciplinary approach encouraged by the Human Rights Centre at the university, and as well as to draw out some historical and theoretical novelty from a topic that is extraordinarily well worn in its straightforwardly legal take on the same set of circumstances. So legal scholars who've looked at this issue have written about it a lot, and I'm not going to be rehashing much of that ground. Some caveats and apologies then before I begin. This talk, unlike most I've given recently, and I'm sure like most given as part of this seminar series, comes not as the conclusion of an extensive research project, but rather at the outset of one. I beg forgiveness then on several immediate counts. The first, of course, is for the fact that as a set of preliminary thoughts, this talk likely poses more questions than it answers. The second, that particularly from the point of view of a detailed legal scholarship and analysis, the talk will be somewhat lacking in detail and nuance. Given the prominence of the case, I will be discussing in canonical discourse on certain key issues in English law. There are certain members of this audience no doubt more familiar with the legal details and impacts of the matter at hand, particularly as they pertain to case law and the relevant statutes. And I look forward actually to hearing from any of you in the audience who do have particular interest or expertise in this area for reasons that will become clear shortly. That said, there are likely members of the audience who know nothing at all of the case, and so I welcome the chance to acquaint those of you for whom that is true with it. The third is that I am entirely unfamiliar at this stage with the technical and philosophical literature in the field of human rights. I come to you as an academic for whom a particular case that was heard before the European Court of Human Rights plays a key role in the histories and arguments I'm thinking about, but for whom its significance in terms of more broadly applicable human rights issues is admittedly secondary to the importance it plays in helping understand the cultural backdrops against which the stories I'm particularly interested in play out. And I hope again in the Q&A that follows this talk to be steered towards the vast oceans of specialist material that many of you no doubt will be able to cite from memory. Right, so February 2017, 3 years in the future from this month, will mark the 20th anniversary of the 1997 European Court of Human Rights judgment in the case of Colin Laskey, Tony Jaggard and Roland Brown. So a judgment ending the legal appeals in a case that had begun as Operation Spanner by the Manchester Police in 1987, and then in the House of Lords as R versus Brown in 1994. I will read directly and at length from the text of the 1997 European Court of Human Rights judgment as it gets quickly and graphically to the issues at stake. And apologies to anyone in the room that's got of a kind of delicate constitution, because there is some detail here. And this is all from the text of the judgment. In 1987, in the course of routine investigations into other matters, the police came into possession of a number of video films which were made during sadomasochistic encounters involving the applicants and as many as 44 other homosexual men. As a result, the applicants, with several other men, were charged with a series of offences including assault and wounding relating to sadomasochistic activities that had taken place over a 10-year period. One of the charges involved a defendant who was not yet 21 years old, the age of consent to male homosexual practices at the time. Although the instances of assault were very numerous, the prosecution limited the counts to a small number of exemplary charges. The acts consisted in the main of maltreatment of the genitalia, with, for example, hot wax, sandpaper, fishhooks and needles, and ritualistic beatings either with the assailant's bare hands or with a variety of implements including stinging nettles, spiked belts and a cat of nine tails. There were instances of branding and infliction of injuries which resulted in the flow of blood and which left scarring. These activities were consensual and were conducted in private for no apparent purpose other than the achievement of sexual gratification. The infliction of pain was subject to certain rules, including the provision of a code word to be used by any victim to stop an assault, and did not lead to any instances of infection, permanent injury, or the need for medical attention. The activities took place at a number of locations, including rooms equipped as torture chambers. Video cameras were used to record events, and the tapes copied and distributed amongst members of the group. The prosecution was largely based on the contents of those videotapes. There was no suggestion that the tapes had been sold or used other than by members of the group. The applicants pleaded guilty to the assault charges after the trial judge ruled that they could not rely on the consent of the victims as an answer to the prosecution case. That's important, that's worth repeating. The applicants pleaded guilty to the assault charges after the trial judge ruled they could not rely on the consent of the victims as an answer to the prosecution case. On the 19th of December 1990, the defendants were convicted and sentenced to terms of imprisonment. On passing sentence, the trial judge commented, "The unlawful conduct now before the court would be dealt with equally in the prosecution of heterosexuals or bisexuals if carried out by them. The homosexuality of the defendants is only the background against which the case must be viewed." We'll come back to that. Mr. Laskey was sentenced to imprisonment of 4 years and 6 months. This included a sentence of 4 years imprisonment for aiding and abetting keeping a disorderly house, and a consecutive term of 6 months imprisonment for possession of the indecent photograph of a child. Under Section 47 of the Offences Against the Person Act 1861, Mr. Laskey also received concurrent sentences of 12 months imprisonment in respect of various counts of assault occasioning actual bodily harm and aiding and abetting assault occasioning actual bodily harm. Mr. Jaggard was sentenced to imprisonment for 3 years. He received 2 years imprisonment for aiding and abetting unlawful wounding, and a further 12 months imprisonment for assault occasioning actual bodily harm, aiding and abetting the same offence and unlawful wounding. Mr. Brown was sentenced to imprisonment for 2 years and 9 months. He received 12 months imprisonment for aiding and abetting the assault occasioning actual bodily harm, a further 9 months imprisonment for assault occasioning actual bodily harm, and a further 12 months imprisonment for further assaults occasioning actual bodily harm. So that's the text of the judgment. Have you get the sense of that? Basically, in summary, these men having sex sadomasochistically, filming it, videos got discovered, they got charged with assault and wounding, exactly as you would if you beat someone up in the street. They said, you can't charge us with this, it's consensual. The judge went, doesn't matter. It went all the way through the House of Lords in R versus Brown 94 and up to the European Court of Human Rights in 1997. And at every stage, the convictions were upheld. In dismissing the appeal, the judges of the European Court ruled that against the appellant's protestations, the case was an infringement of their Article 8 right to privacy, stating, quote, the national authorities were entitled to consider that the prosecution and conviction of the applicants were necessary in a democratic society for the protection of health. And, quote, the court, like the Commission, does not find it necessary to determine whether the inference with the applicant's right to respect for private life could also be justified on the grounds of protection of morals. So there's a clause in the Article 8 protections which say that the governments cannot interfere with the right to privacy unless it's for the protection of health or the protection of morals, amongst other things. The European Court found it sufficient to judge that this case was sufficiently in the public interest in terms of health, that they didn't even consider the moral question. The ruling and the subsequent clarification in British legal jurisprudence that individuals do not have the unimpinged rights to bodily autonomy, particularly where body modification is concerned, and especially if sexual motives are in play, thus marked a vindication for the British authorities and the establishment of a piece of legal precedent that has become one which has regularly been cited in subsequent judgments, was taken into account in the preparation of later statutes, including the Sexual Offences Act 2003, where it shed light on issues of consent in the law in terms of sexual conduct, and the Criminal Justice and Immigration Bill 2007, in which its rulings were cited in defence of the government's cracking down on what became known as extreme pornography in the law, is almost paradigmatic in intro to law textbooks for undergraduate law students, and which continues to cast a pall over the legal attitudes in this country to those, particularly homosexuals, who choose to engage in non-normative sexual practices. 2017, as you will note, will also conveniently mark 30 years since the initial arrests in 1987 that led to the prosecution of these men for entirely consensual, if hardcore, sadomasochistic sex acts. The research project we are embarking on, and especially as this talk is being recorded, I must explain that quite unequivocally, for it includes not just me with my interest in body modification history, but my colleague Alex Dimmock, a PhD candidate in law at the University of Reading, an expert on masochism in the law, and a key member of the pressure group Backlash, who campaign on issues pertaining to the freedom of sexual expression. And Dr. Dominic Johnson from Queen Mary University of London, a scholar of contemporary performance art, including the impacts the Brown rulings had on performance art practice in Britain throughout the 1990s and beyond. So we aim to produce, in time for the 20/30 year anniversary, a collection of essays, commentaries and revisions of prior work by scholars interested in the issues the Spanner case poses. Of particular interest to us are the impacts the Spanner judgment has had in the cultural field, rather than perhaps its subsequent life as a piece of case law. Alex, with her interests in masochism, finds the discourse around sexual identities, particularly those of BDSM and kink, as well as the distribution and consumption of images from within and looking into those communities of particular interest. And the Spanner case, its commentaries and its fallouts mark something of a Rubicon in recent British histories in that field. It also marks a key moment in sexual activism, with the case leading to the establishment of the Spanner Trust, an organisation which exists to this very day to defend the rights of sadomasochists in the consensual expression of their sexual identities. And they're still working tirelessly to challenge the Spanner ruling, which, as I've said, still remains in force today, although the interests of the authorities in enforcing it perhaps aren't as high as they were in the late 1980s. And have played key roles in the consultations around recent legal and statutory moves on sexual autonomy and freedom. Dominic has written extensively around issues of intimacy and live art, including the impacts the Spanner judgment had on the staging of live art, which incorporates acts of wounding, a common trope of performance art practice during the body panics of the AIDS crisis and since. Dominic writes about British artist Franco B's performance, Protect Me. Forgive me, this is an image from a different performance, but it gives you a sense of Franco's kind of performance style, which is very bloody and very self-injurious. And I quote from Dominic, "In a performance for camera in 1990, a collaborator carved the words, 'Protect Me,' into Franco B's back using a scalpel. In turn, his friend's back was inscribed with the solitary word, democracy. The performance appropriated the precise methods that had been criminalised in R versus Brown, but articulated the painful realities concealed within the court's decision. Through brutally concise, poetic means, Franco B demonstrates that democracy is a selective apparatus directed at protecting the minority at the expense of the self-determination of those at the margins. The punishment of SM practitioners as a result of Operation Spanner was defended on the pretense that to do otherwise would be to, quote, give licence for the corruption of the young or the proselytisation of activities amongst adults, as if somehow people who saw these would be encouraged to copy them. Franco B's performance aptly shows that democracy may come at a cost, and that the safeguarding of social conventions often involves the punitive protection of consenting adults from their own desires, each in the name of an ill-defined higher good. Moreover, Dominic goes on to describe the chilling effect the case had on the performance of important live art involving self-injury by canonical American performance artist Ron Athey at the ICA. Those of you in my performance class and my contemporary art class will kind of know this case a little bit already. Athey had been booked to perform 4 scenes at a season called Ask the Angels at the ICA in London in July 1994. And as a bit of background, Ron had already sort of gotten a bit of notoriety for this case in America, where basically a complaint regarding the public funding of his work had erupted in Congress. And like a big kind of moral panic based around the fact that he was cutting bodies on stage. He's HIV positive, but his blood wasn't being shed on stage. And there was this big kind of massive misreaction to the piece in the American media, and this huge kind of furore in Congress, where he became kind of one of the totemic figures of what became known as the culture wars in 1994. And as I said, he's on his way to London in July 94. Operation Spanner and the concomitant convictions had recently become newsworthy again due to the failure of the protracted appeal to the House of Lords. Moreover, the defendants had recently taken their appeal to the European Court of Human Rights. At the time, Lois Kyden was Director of Live Arts Programming at the ICA. She recalls that the ICA raised concerns about its potential culpability for soliciting acts that had been recently reaffirmed as criminal in the eyes of the law. Upon consultation, the Board of Directors refused to host any parts of Athey's performance that could provoke media outrage or legal proceedings. In a critical preview published by The Guardian, Claire Armistead linked anxieties about Athey's performance to fears of legal repercussions. And I'm still quoting from Dominic here. Armistead highlighted the problem posed by 4 scenes in punishingly terse terms. Whereas self-mutilation is permissible, the involvement of another person is not, explaining that this legal anomaly meant that British law had forced changes in Athey's act. Athey's act involved, as you can see still on the right, there's not very much good photography of this, and what does exist is mainly through clips from a quite grainy video. And you can see part of the performance involves him cutting one of his co-collaborators' backs, and then taking swab or taking kind of prints of the blood using kitchen paper, and then with this apparatus, which you can just make out in the corner, suspending it over the heads of the audience. And by the time this reached the American media, and when it was reaching the furore in America, this was read as bags of HIV-infected blood dripping on the audience. Right? That was the American tabloid take on this performance, which clearly wasn't what was going on, but nevertheless. So, to avoid litigation and scandal, Athey was urged to find creative solutions to 2 banned sections, the human printing press, which I've just described, and a queer wedding ritual in which Athey pierced the cheeks of 2 members of his company. Athey chose to show a video of the former and modified the ritual by having Julie Tolentino and Pigpen, 2 of his collaborators, pierce themselves on stage, which was deemed permissible under the law. The 3 of us think then, along with a number of legal and cultural scholars before us, that the rulings in fact, reaching its ultimate conclusion in the European Court of Human Rights case in 1997, is deeply wrong, particularly on moral grounds, as it stands accused by several writers since the judgment of, amongst other things, paternalism, of being patronising, and in some quite profound ways illustrating a deeply embedded homophobia in British law. It's worth stating for the record that in heterosexual cases where Brown has been cited as a precedent, including the case of R versus Wilson in 1996, where a man was convicted of branding his wife's buttocks, again at her request. None of the women involved have ever been charged, whereas in the Spanner case, even the men who were undergoing the masochistic acts, who weren't participating in producing the harm, were charged with aiding and abetting the crime. Right? So that doesn't happen in any of the heterosexual cases which follow. Indeed, this is the role the case often plays when cited in legal textbooks, and maybe some of you here have already discussed it in the various classes in your courses of study, to spark thought about the acceptable limits of the arm of the law into people's bedrooms and onto their very bodies. Nevertheless, this critical reading of the case is by no means universal. Alex, when teaching about the case to a class of undergraduates, was met with a room of students who considered the prosecution of these dangerous perverts justified, and depressingly in exactly those terms. She was quite shocked, actually, as kind of a young, still doing her PhD lecturer. She sort of thought she'd go into this kind of room and raise hell at the radical injustice of this case, but actually found herself with quite a conservative bunch of young people who were quite happy that these people were criminalised. I share both my colleagues' interest in the case, obviously. But for me, the story of Operation Spanner, the subcultures it revealed, and the impacts it had are of principal interest as they help elucidate the history of body modification in Britain, particularly tattooing and piercing. 1994, the year of the Brown ruling, marks a key moment in contemporary history of body piercing, as it was that year too that the video for the Aerosmith song Cryin' promoted navel piercing on a young Alicia Silverstone to a pop culture audience, and sparked a trend which survives even to this day. And you can see piercing featuring on the cover of both the single and the album Get a Grip, in which the song Crying appeared, right? Piercing becomes this motif in the Aerosmith records in '94. The Crying video, which features Alicia Silverstone as a young rebel kind of running away from home, first thing she does, get her navel pierced. And in those days, we all used to watch MTV and stuff, and there were music videos on MTV back in the day. Shock horror. You don't get much of that anymore. But this is kind of the moment when body piercing hits the mainstream, right? This is the moment when particularly kind of navel piercing for girls hits the kind of cultural trend, right? Before this, it's not really happening anywhere visibly. This is kind of a Rubicon, the moment in time at which body piercing becomes an acceptable, heterosexual, middle class, although albeit slightly rebellious fashion trend. Same year as the Brown rulings are being doled out. It's still not legally clear, in fact, as far as I can tell, where professional body piercing, particularly of the genitals, might fit into the legal framework Brown establishes. Moreover, practitioners of the more extreme modes of body modification that were also beginning to reveal themselves to a wider set of audiences from the late 1980s onwards, and 1994 is also the year that a body modification website BME Zine is founded, including implants, sub-incision of the penis, and later tongue splitting, also seem to find themselves open to prosecutions under the logics of Brown, especially as these are usually performed outside of a system of licensed premises. As an art historian, I'm also fascinated by the role the videotaping of the initial orgies play in the history of the case, and what the opinions of the judges on the committal of the committal of these acts to tape might tell us about the general theories of the depiction, viewing, and distribution of violent images, sexual or otherwise. The taping of the acts ensured the initial arrests and served as an illustration for several of the presiding lords that not only could these acts not be considered private, they are also potentially dangerous for the wider community, including inevitably children who might inevitably stumble across them. As an aside, by the way, an acquaintance has offered to show me a copy of the videotapes in question, or at least what he claims is one of the videotapes in question. I've thus far refused, as I'm not even sure to what extent even I, as an academic accessing it for research purposes, might be liable for prosecution for possessing such material. And actually, the fact that he even has a copy probably undermines some of the Spanner defence that they didn't distribute the videos anywhere. That's something I need to think about a bit more. The case also falls squarely into the period of the fallout from the video nasties panic, which resulted in the Video Recordings Act of 1984 and the banning from home video of several notorious films, including stone cold classics like The Exorcist, The Evil Dead and Tenebrae, and less artistically defensible fare such as Driller Killer or Cannibal Holocaust. A sense that depictions of violence, simulated or otherwise, available to view in one's home, was a scourge on decent society. And I think this is interesting, and a kind of aspect of the Spanner case that hasn't really been thought about very much, that in the kind of years preceding the arrest and the trawl of the original Spanner arrests, basically one of the Spanner men was arrested for a separate crime, and in searching his home, the cops found these videotapes. And I think probably the very fact they're interested in videotapes stems from this kind of cultural climate around the fear of these video nasties. As video recorders become more popular in Britain, and as kind of these films start getting released on home video, these horror movies, there's this massive, massive moral panic, right, in all the newspapers on both the left and the right to ban these video nasties. It's a huge kind of important moment in the history of British film. I find this really interesting because this is the front page of the Daily Mail from the 1st of July 1983. Ban video sadism now, right? And of course they're talking about films like The Exorcist, right? But I think this gives us a nice sense of the climate of discourse into which the Spanner case is occurring. There's this really interesting visual culture aspect to the whole discourse around the prosecution, the reasons it comes to trial, all the kind of reasons, in fact, many of the reasons why they get convicted in the first place, that revolves around the visual imagery, which no one's really properly, to my mind, teased out. So there's another kind of impact. Most importantly, though, my interest in the case centres around the inclusion of one particular individual in the scope of the initial arrests and convictions. Though not party to the later appeals, including the final appeal to the European Court of Human Rights, the presence of one Alan Oversby in the initial group of over 40 men and what the interest in the case revealed about his sexual practices tells a key set of stories about the histories of professional tattooing and body piercing in this country. Alan, better known by his professional alias of, you've guessed it from the slide, Mr. Sebastian, chosen naturally after the famous pierced saint, pierced in a slightly different way, of course, was born in Liverpool in 1933 and became enamoured with body piercing in the 1950s whilst working on a sugar plantation in British Guiana. He'd seen nipple piercings on some field hands and persuaded one of them, over a few glasses of rum, to pierce him. Returning to Britain, he trained as an art teacher in the Midlands and became increasingly enamoured with modifying his own body, first by re-piercing his own nipples, and then imitating an illustration of an African man he'd seen in an anthropology textbook, inserting a ring into his foreskin. Eventually, he got tattooed. And Alan was first tattooed by George Burchett, the most famous British tattoo artist of the 20th century, and regarded by a recent biographer as elegant and skilled. Burchett's really this kind of key pivotal figure in the history of British tattooing, and I think it's wonderful that Alan's kind of linked into his story. And it's in Burchett's shop that Alan first meets other pierced Englishmen. As Burchett played such a crucial role in the history of British tattooing, he was sufficiently famous in the 1930s that he featured on a cigarette card. It's thrilling to see that his shop served as the catalyst for what was to follow. Alan also talks about seeing images of pierced people on the walls of Burchett's shop, kind of again the kind of anthropological photography. After having realised there might be a market for the skills he had developed in piercing himself, he would go on to open the first professional body piercing studio in Britain, in Wandsworth, South London. And as a trained art teacher, the presence of tattooing in his shop, the fact that he also worked as a tattooist, also marks him out as the first artistically trained tattoo artist in the country. Most relevantly to the Spanner case, though, in an interview for the San Francisco-based Piercing Fans International Quarterly in 1978, so sometime before the Spanner convictions, Alan also admits to have been driven to pierce professionally due to the lack of sterility and care taken during piercing taking place during exactly the kind of orgies the Spanner case would revolve around. Quote, I saw a couple of men getting some piercings during some sort of S&M scene. Everything was so filthy, dirty and unsterile. I remember thinking the surroundings aren't so good, but that doesn't matter so much if whoever's doing the piercing is neither drunk or unwashed and the equipment is clean. That's how I first thought that somebody ought to be doing something a little better, and so I set out to learn. It wasn't easy. I had a couple of friends who were doctors, so I could speak with them. Neither one of them thought much of piercing, but they were willing to give me what information they could. So gradually, beginning with them and thinking things out for myself, quite a lot of my piercings really were done not because I particularly wanted them, but because I wanted to find out about them. I didn't particularly want the nose piercing I've got now, but I didn't particularly want it at all, nor a navel piercing. 1978. So perhaps not even just the kind of orgies. Perhaps the spanner tapes included the exact moment that inspired Mr. Sebastian to open his studio, travel to the west coast of America to learn from the fathers of the modern body modification scene, Jim Ward and Doug Malloy in Gauntlet in San Francisco, and to develop the skills that would see him, by the late 1980s, hailed as none other than the avant-garde artist and musician Genesis P-Orridge, as someone who, quote, had taken tattooing to a higher art and who was poet and philosopher and historian all at once. Here's a close-up of his nipple piercing, stretched quite large, which is, again, very interesting and unusual considering this is 1978. Here is his aforementioned pierced penis, which he said initially with a leather punch. I wouldn't recommend that you try that at home. Although he says that it wasn't painful very much and it healed very quickly and it was all fine and he enjoyed it very much. I'll take that off there. This is the ad for his studio, and you can see there, Leather Unlimited, 342 York Road, Wandsworth. 1978, the first professional body piercing studio in the country. And here's Genesis and Paula P-Orridge. Genesis P-Orridge, for those of you who don't know, is an avant-garde musician, founder of the group Throbbing Gristle and Coombe Transmissions and Psychic TV, involved really at the kind of forefront of the industrial scene in Britain and a kind of important visual artist in his own right. Much of his work is now held in the tape. And it's Mr. Sebastian who's tattooing him and piercing him. It seems deeply problematic to me and bitterly ironic that although piercing other people was not an entirely sexual act for Mr. Sebastian, he explains in an interview that he has to be emotionally detached from the process of piercing in order to be able to do it well, even if he found the results sexually arousing on occasion. This act, which began, perhaps even directly in these demonised videos, would by the time their participants were in court be a burgeoning teen trend. Doesn't that make you angry? That makes me quite angry. Note his mention of a navel piercing. From homosexual orgies to the belly buttons of pop-obsessed teenagers, we can draw a direct line from the gay S&M subcultures of London and San Francisco to the body art trends of the 1990s. What is now in some form so normalised, as the ECHR has it euphemistically, the infliction of injuries which resulted in the flow of blood, condemn these men to imprisonment. Alan's sentence of 15 months imprisonment was suspended for 2 years, so he never actually went to jail. And the particular cultural and legal consequences of these links remains unexplored in any great detail. There are, of course, key questions in legal terms here, especially in terms of motivation. But for the sake of this talk and the limited time available, it suffices to point out that the professional body piercing in this country begins with a man arrested and convicted in part for carrying out in private what he would make a living from doing in public. This central role in the history of British body art by an openly gay man with a well-documented and publicly recorded sadomasochistic sexual appetites, as mentioned even before the Spanner case, Mr. Sebastian spoke openly of his sexuality in interviews, is also fascinating for the historiographies I'm tracing of tattooing. Mr. Sebastian, Genesis explains in an interview for the book Modern Primitives, a landmark book which kind of inspired a lot of people to kind of take up these practices in Britain, and which Mr. Sebastian was actually importing from America. He was the sole kind of UK source for that book for a while. So again, he plays a very important role. I've written a whole separate article about that, so I won't go into that in too much detail. Genesis explains in the interview, Mr. Sebastian used to teach an art school for children between the ages of 11 and 16. He did etchings and engravings. He's a very skilled draftsman. But his actual, certainly semi-sexual fetish was piercing and tattooing on himself. And so he left his teaching job and went into tattooing full time. He does very fine work with the thinnest needles, and it takes a long time to do tattoos. He's probably the slowest in England. In speaking with his contemporaries in the London tattoo scene, and I've spoken to a lot of people who were running shops at the same time, who were kind of his friends or his competitors in lots of ways, it's clear he was well thought of and well regarded, innovative, talented, and passionate. Contrary to many less carefully evidenced histories of tattooing in the West, the central role played by an art school trained, openly homosexual man in the development of the art form speaks to a hitherto unexplored plurality in the production and consumption of tattooing, and moreover, the vilification of the lifestyle by the courts and the popular press seems particularly incongruous given the crossovers that lifestyle increasingly had at the peak of the court's condemnation. And here are some of the details of his kind of fine line tattooing. There's lots of kind of esotericism in these imagery, which likely comes more from Jen than it does from Sebastian. There are, as far more eloquent authors than I have explained, an inordinate number of intricately drawn human rights issues arriving from Brown. Where do rights of bodily autonomy begin and end? What counts as private? How does the law treat homosexual and heterosexual individuals differently in similar circumstances? What role does and should consent play in assessing questions of harm, amongst many others? And as I said at the beginning, legal scholarship on this case is voluminous. What is missing, as I and my other colleagues want to argue, is the broader case. That the very attitude to human rights betrayed in the national and supranational rulings in the Spanner case is indicative of deep-seated and as yet unresolved problems in the historiographies of several areas of cultural production, particularly incoherent social and medico-legal attitudes towards bodily integrity and autonomy, and in the way we understand the recent history of our own country. This is a real kind of dark spot on recent cultural legal history in the UK as far as I'm concerned. R versus Brown, the subcultures it rendered public and the impacts it continues to have are ripe for a set of conversations that stretch beyond the narrow interpretations of its role as a pivotal and still deeply controversial legal ruling. I finish up just with this image, which is from the same interview with Mr. Sebastian in the 1978 image. And what I like about it is it shows him mucking about, right? Here's Alan. This is a guy called Sailor Sid Diller, who's a kind of important figure in American body mod history. And this is Jim Ward, the guy who opened up the first open professional body piercing shop in the world in San Francisco, Gauntlet, and they're mucking about. And I love that because it shows a kind of attitude to their bodies and their practices, which is sort of so, I mean, despite all the kind of politics and despite all the sexualization and despite all the kind of fetishization that we've just been talking about for the past kind of 40 minutes, what we sort of see in this last image is this idea that it's just fun, right? It's just something that's so much part of who they are, so much part of their own identity, so much part of how they live their lives, that kind of this is a kind of them playing about and having fun in a kind of completely non-sexual way, but it's just kind of hilarious, them hooking their septum rings together, right? Thank you. So I think we've got a bit of time, so that was about 40 minutes. I think we've got about, maybe even the same again if we need it, to do some Q&A and ask some questions if you have any. I mean, actually, I would be really interested to hear from any of you who have different takes on that case, who have studied the kind of legal consequences in more detail than I have recently, and who kind of want to concur or disagree with anything that I've been saying. Yeah.
I just had a question.
Sure.
Do you think if the case was today, do you think the outcome would have been different?
Well, that's an interesting question. I think the fact that as recently as 2008, the government we're still citing it as precedent in, as I said, the kind of criminal justice bill that led to the criminalisation of extreme pornography and what's permissible and what's not permissible to represent sexually in terms of kind of video recordings or their digital equivalents. I don't know. That's a good question. I mean, the Spanner Trust are still preparing an appeal. Their work's still ongoing. They still want to kind of exonerate these men. Colin Laskey unfortunately died even before the ECHR ruling. Alan died in the late 1990s as well, in 1996. Brown and Jaggard are still alive. I think that's correct anyway. So they're still kind of fighting to clear their names, right? I don't know. I wonder, because there's so much. I mean, this kind of moral panic about won't someone think of the children, and this idea of kind of contagion, this idea of kind of moral panic is still quite prevalent. And I can still see, if this case happened today, if this same thing, was uncovered, let's say, in the course of a raid for something else, they found videos with these same scenes on them. Would it still end up on the front page of the tabloids? Yeah, certainly I think it would. And I think certainly it would provoke kind of hue and cry. So, maybe we haven't come very far. Well, what do you think?
Yeah, maybe. I think it still would. Yeah.
I mean, the counter-argument to that is that this statute's still in the books, but there haven't been any prosecutions directly under it for a while, right? I mean, the police aren't going out trying to kind of, lock up S&M practitioners, and the Sexual Offences Bill 2003 did kind of clarify a little bit the law on consent in sexual offences, which puts the burden of proof on the accuser. So in that respect, things have moved on slightly, but I think there's still the kind of scope of this and the specularity of it, the kind of visual element to it, I think still probably makes answering that question a really difficult one. And maybe actually in the course of this project, as I said, which is going to happen over the course of the next 2 or 3 years, we'll try and see if we can figure that out, right? Ask some lawyers and ask some people that wrote reactions to the case back in the late 90s what they think of now. Like, have a look at that, whether we moved on. I mean, does anyone have any other opinions on that, whether that particular kind of question of whether such a kind of case would be pursued today? Yeah.
And I think it depends entirely on what you regard as the main holding in Brown, because if it is about limits on consent, then yes, absolutely, because that is, I mean, it is the case.
Absolutely.
And it is absolutely applied. I think the main question would have to be posed slightly differently, which is, of course, how do you determine whether the public interest would still be in terms of limiting consent under certain circumstances would still be interpreted in the same way. So I think it depends on that. So in terms of what it says about consent, and that consent is only valid if a certain act that is a violent act can be regarded as not violating public interest. Yeah, absolutely. I mean, it has been quoted in all sorts of circumstances, from euthanasia to whatever. So it's a very clear legal precedent on those ones.
Yeah, no, absolutely. Yeah, thank you for clarifying that. I mean, it also draws upon, if I'm right, it draws on kind of Victorian statutes on boxing. Is that correct? Like the judgment. So there's this real kind of deep history of these kind of issues. So yeah, thank you for clarifying that. Any other questions? Yes, please.
Follow this up,
yeah.
I just wanted to ask you then, is your objection based on the idea that you think consent, or the validity of consent, should not be limited under any circumstances, because that would be paternalistic if the person is able to make a valid free choice, or is it the way public interest has been interpreted in the particular context of homosexuality?
I would say it's a mixture of both of those things, and the second one kind of enlightens my reaction to the first. I mean, I certainly agree that I think this case gets the limits on personal autonomy wrong. I'm certainly not alone in thinking that. I think that, but I think the fact, the kind of use to which it has been put, particularly the kind of differing use to which it's been put in the prosecution of homosexuals versus heterosexuals, I think gives lie in some respects to the attitudes which underpin its deployment, right? I think it speaks to a set of attitudes, it speaks to a set of, and this is kind of coming back to the first question in a way, I think it speaks to a set of attitudes which are much more deep-rooted than the kind of issues at play in those cases, and they speak to things, they speak to kind of questions of body horror, it speaks to questions of fear of contagion, it speaks to questions of all the kind of things which we've been talking about. So, I mean, it's not a particularly satisfying answer, but I think the answer is actually like both. It worries me that these men, in the particular case that we're talking about, and then the wider kind of applications in the conviction in Wilson, for example, it worries me that we're policing consensual sexual activity because it feels kind of icky. It feels like, I mean, I've spoken a bit about discourses around plastic surgery too, and that's a whole other separate issue, but most of that is or a lot of that is predicated on wow, that must hurt and wow, that must be dangerous. And I think that's what's at the root of this too. I think it's wow, that must hurt, wow, that must be dangerous. I wouldn't want that to happen to me, therefore no one can have it happen to them. And I think that's kind of, it's those kind of issues which this case reveals to me. And I think that the reason I guess me and my colleagues are interested in the cultural context is exactly trying to maybe pick out the answers to that question, right? Maybe work out that, okay, I think obviously it does have some utility, right? As you said, this is a case which is cited all the time in euthanasia, in like all kinds of, in spousal abuse cases and all kinds of things, but the kind of wider stories that its deployment tell us seem to me ripe for more investigation. So I hope that makes some sort of sense. Yeah, thank you. Yeah, hello again.
I don't understand the plastic surgery. Do you think that plastic surgery and this is kind of the same situation? Would you say that plastic surgery is more pressure maybe, or because
yeah, okay, I've opened the can of worms there I didn't mean to open. I mean, broadly yes, but let's not go into that because that's a whole different set of questions. But I think the discourse is interesting. People, a lot of even otherwise quite careful writers who are objecting to cosmetic surgery do so primarily on the issues of violence and the affliction of violence, right? And the breaking of the skin, and there's lots of talk about bleeding and blah, blah, which is that the kind of rhetoric which you see in the Brown judgment, right? You see all this talk about blood, about pain, and in fact, and how the judgment wraps those terms up in the kind of the legalistic framework is really interesting. But I think it speaks to almost this kind of empathetic problem that we kind of, and again, those of you that have classes with me know my interest in these issues, but when we look upon the suffering of others, we are inclined to feel suffering ourselves. That's kind of a basic physiological fact of human existence. And what we do with that emotional reaction is important. And I think a lot of people, I'm being really general here, but I think as happens in lots of reactions to Brown, is exactly the same as happens in lots of reactions to plastic surgery, which is that, wow, that must hurt. Why would they want to do that to themselves? They must be crazy. Therefore, I have to protect them, right? That's the kind of logical chain. And I think the break in that is there's a missing step, which is, okay, it hurts. Does that matter? Right? Or why does that matter? Why is that important? And for people that are and this is where plastic surgery and this aren't the same, because the reasons for undergoing painful procedures are different in both cases. But there's a logic to the pain in both cases, which isn't kind of thought through in those objections. Let's put it that way. So, I mean, I've elided lots of very complicated, or lots of very much more kind of nuanced points there that I've talked about in more detail in other venues, but I hope that kind of clarifies that slightly. Yeah, thanks. Hello again.
I just wanted to confirm what you just said, because I think the important point is really the reason behind what people inflict on themselves or that other people inflict on them, and how we as society
Yeah.
It is really the reason behind it.
And I mean, and that also comes into exactly what I was talking about in that last sort of quarter of the talk about professional body piercing, because it is still unclear the legality of genital piercing. And if you claim that you want a genital piercing for a sexual reason, it's probably illegal to get one under the Brown ruling. If you just want it for aesthetic reasons, maybe it isn't, right? But the fact that the aesthetic and the sexual piercing come from exactly the same place in culture, and it's rooted directly, probably in one of the Brown videos, right? The piercings which he's talking about, he's part of that group. They're filming it. So one of those videos that the Spanner men were charged with for possessing, and that led to the whole prosecution in the first place. One of those is probably a video of the orgy where he decided that he needed to professionalise body piercing, right? So like that is really, really amazing, and not something which anyone's, as far as I know, picked out, right? That connection, because that exactly makes visible those objections. Why are we worried about people doing one thing, for one reason, when we're perfectly fine with people doing it for another reason, exactly at the same time, by exactly the same people, actually, and it's worth thinking those issues through, I think. Can I ask in the room if anybody wants to stand up for the judgment? Because I said it's quite easy for me to come here, and I've been thinking about this. I mean, ever since it happened, really. I remember it being, especially the '97 judgment, because that was at the height of the very sort of beginning of my interest in this stuff, and it's partly the reason why I'm standing here today, actually. So it's quite easy for me to stand in front of you as a room and say that I'm outraged by this, and I find it deeply problematic. But as I said, my friend Alex made that same leap of faith, I guess, that she thought that she'd have a sympathetic crowd when she was teaching her law undergraduates at Reading, and she found some hostility. So I wonder if there's any of you who'd be brave enough in this room to kind of stand up for the Brown judgment, who wants to kind of say, yeah, okay, this conviction was justified, and kind of support the learned judges across all three levels of the legal system, and say, yeah, I can understand why that was made, and I think it's a legitimate judgment. Nobody. Either I've completely convinced all of you, or you were all wonderful liberal people when you came in, or there's some cowards in the room. It's one of those three options.
Why do you think it was the right ruling at that time, but nowadays it wouldn't be as acceptable?
Do you want to elucidate that a little bit?
I agree that the ruling was right at that time. I myself am even slightly sick and watching the pictures.
Sure, and then that's perfectly natural reaction. Yeah.
I'm not used to the kind of pictures, as you saw from my friend who walked out.
Yeah.
Very sick and very earlier on. So I see there are some people who would have their health affected by this, but with other things it's a matter of exposure. If we've been exposed to this before, we could have gotten all used to this being a normal thing. Those judges who probably did the ruling were not people who were used to this kind of thing, probably saw it very out there and didn't want in general, knew that there were a lot of people like themselves who probably wouldn't be okay with this.
There's a really interesting article on the case, actually, which I didn't talk about, which says that his theory, this is in a book called Law and the Senses, and the theory in that article is that the reason that the judges felt so uncomfortable with it is because the descriptions of the actions undertaken, right, that the defendants were charged with, really, really resemble English legal systems of torture, right, before the advent of before the removal of state-sanctioned corporal punishment. And actually, there's some kind of resonant guilt, right, in the judges, that they're so horrified not only by the actions but by their own complicity as part of this teleology of a legal system which once used these exact same practices as punishment, right? And that actually part of the logic of the judgment was to try and absolve themselves of the guilt of being part of a legal system which, just a few 100 years earlier had kind of. I don't quite buy that, actually, but that's certainly one of the readings that. There's something particular about judges which makes them particularly averse to this kind of thing. Although that said, I'm given to believe from my friends who are professional dominatrices that some of their best clients are judges. So make of that what you will. Yeah?
But the claim was private life, so they
Yeah.
didn't really wanted to show it to anyone, they just wanted
Yeah.
to do it themselves. So
Absolutely.
And I think that judges should think about private life, not about public.
Well, I mean, that's interesting because part of the logic in the ECHR judgment is that the fact that they filmed it means that it wasn't as private as they thought it was, and that was part of the objection. I mean, again, the insistence on all the participants is that they only filmed it for their own consumption and it wasn't for distribution. As I said, the fact that I know somebody who has a copy of the video might give light to that, or at least claims to have a copy of the video. I haven't verified that. So I don't know. I think you're right to pick up on that as an issue, and it's one that interests me, as I said, as a visual historian. I don't think it's a coincidence that it's only 4-5 years between this idea of videotapes being dangerous, this idea of videotapes being, particularly dangerous for children. I don't think that's a coincidence, and again, something which I haven't seen picked up on in much of the other scholarship, although it is occasionally mentioned. And that also I think gives. This is again why it's interesting, why the ruling's interesting now, because as I said, it's been deployed in the extreme pornography laws, which say that even simulated harm is not permitted. Right? You can't even have pornography in which not only are all the participants consensual, but no actual harm took place. It's just simulated harm, which again makes you go, well, hold on a minute. We can watch kind of Arnold Schwarzenegger movies all day long. Pardon my 1980s reference, but you kind of get the point. But when we put that into kind of a sexual context, or a context designed or ostensibly to promote sexual response, then it becomes problematic. And again, that's something which hasn't quite yet been tested in court. And again, comes back to, I think, what you were saying about intention. So there's all these routes, right, which this, hopefully, it seems to me the room agree is quite problematic ruling, which still remains in force and which still exerts a certain pressure on the kind of things we can do. And as the kind of particularly the kind of visual aspects with the internet and distribution of images comes into place, these rulings become ever more important, right, and ever more kind of applicable. You sort of, all of us run the risk of running into these in some sense or another. Me probably more than most of you, but the point still stands. Any other questions? No? Okay, well, thank you all for coming. As I said, I hope that was suitably interesting and thought-provoking. I mean, I apologise again for not having any real firm conclusions with this, but, in 3 years' time, hopefully there'll be a book which you can all read. And we might have something a bit more firm to say. But suffice to say, I think this is a set of issues which need talking about, and hopefully at least some of you will kind of go away and think about them in some more detail. Thank you very much.